Court does call the case, People versus Jesse Lee Rogers.
Senator John Evans on behalf of the people.
Good afternoon, Your Honor. Alex Warren Green on behalf of Ms. Rogers. Ms. Rogers, could you please state your name for the court?
Jesse Rogers.
Thank you.
Your Honor, thank you. Good afternoon. Today, the date and time set for the preliminary exam in this matter. I had an opportunity over the weekend to review the reports. I spoke to Mr. Warren Green. There is a handful of documentations that are alluded to within the report that neither party simply has. I went through it and I'm not sure. It doesn't look like it ever happened. I reached out to the records department of the sheriff's office as well as the OIC, who now is at a different police department. And they're looking into it, but I've not received those documents as of this time. I am unable to adequately perform this exam. And so I'm going to respectfully ask for.
Why weren't, I don't understand.
And Your Honor, our position is I'm asking for a dismissal. When we set this examination, I set it with the understanding that we had everything the people had. And I believe that to be true today. I'm asking for a dismissal because I don't think it's the case that discovery is incomplete. I think the people are simply missing evidence they need to move forward with this case.
Well, which is it? I mean, there are things referred to, what I got out of that was there are things referred to in the report. Do we know whether they exist or don't exist? And if they exist, why haven't they been given to the defense prior to now, and certainly prior to the time that this examination was set?
So the report refers to a couple of different items, i.e. a spreadsheet from the University of Michigan Credit Union, as well as a phone call. And it says that the phone call was uploaded to evidence.com. I go to evidence.com, I don't have it. It's just not there. The spreadsheet, there's something that might be the spreadsheet, but I'm not sure if it is the spreadsheet. So there's things that are in the report that I don't feel comfortable. The phone call, I just don't have. The spreadsheet, maybe it's there. I'm not 100% sure that that's what the spreadsheet. It doesn't look like a spreadsheet, but
I don't know what that means. Is it a spreadsheet or isn't it? I mean, if it refers to a particular document, I think you'd be able to try to figure out what it is.
I think if it was copied and pasted from Excel and then into a Word document, it would have just been a formatting error that I wouldn't necessarily be able to make heads or tails of.
And Your Honor, what the defense is in possession of is what purports to be the complainant's banking app records. Those are contained in what is a spreadsheet, and that was produced. What I think the people are missing is Verizon records that are mentioned in the report, but were not produced, are not in the people or the prosecutor's office possession, and certainly haven't been turned over to the defense. I believe we have everything they have.
Why are those records as a proffer necessary for the exam?
The way that I believe that I can prove the case is to show the connection between the defendant and her use of an IP address that comes back to her phone number. And I don't have any of those documentation.
Then how did it get charged?
It's a good question, Your Honor.
Oh, yes, it's a good question. And I don't know whether she's guilty, not guilty. She's presumed to be at this point in time, but she's been going through this process and get to the date of a preliminary examination, her first step. And you're telling me you can't show the case and that there's something out there that you don't have, never had, that would link her to this case. So why is she? Going to grant the defendant's motion. This case is dismissed. It is without prejudice. So, ma'am, you need to understand that they can bring the case back but I'm gonna give you fair warning. You bring it back, you better be ready to go. You better have everything that would tie this defendant to this case, or there are really going to be problems. Thank you.
Thanks, Your Honor.
Thank you, Your Honor.
Or it does call the case, People versus Dylan Chapman.
Your Honor, Alexis Plumey, Assistant Public Defender, appearing with and on behalf of Mr. Chapman. Mr. Chapman, could you state your name for the record?
Dylan Chapman.
Thank you.
And Your Honor, today is the date time set for preliminary examination. I understand there is a bond violation. However, also at this time, people are unable to proceed as to counts 1, 2, 3, 4, and 5, and would ask for count 6 and 7 to be remanded down to district court.
So you're unable to proceed on 1 through 5
Correct.
and would like 6 and 7 down. Got it.
Correct.
Counsel, you're moving to dismiss counts 1 through 5.
Yes, Your Honor.
Continue to defendants not guilty, plea yes to count 6 and 7. Set this matter for pretrial.
January 29th at 10:30 for Judge Fresh-Hour.
That date might change. There's an in custody. We'll see, but you got the 29th right now, correct?
Yeah.
Got it. What time? 9?
10:30.
10:30. Before Judge Fresh-Hour. As to the bond violation.
Yes, Your Honor, I have had an opportunity to discuss the violation with my client. He has provided me with an explanation that he feels comfortable with me sharing with the court. This was reported as a hit and run accident. Mr. Chapman states that the complainant in this case was using his car, which she had reached out to his mother and asked if she could borrow because hers was either broken or not able to drive in the snow. He states his mother gave her the keys to the car and allowed her to use it. And then Mr. Chapman states that at some point that night, his mother called him and let him know that the complainant had been involved in a hit and run accident with his car. He tells me that he did go to the scene of the accident to try to check on his vehicle, and that at that point, the complainant was not actually present. It's unclear to me in the report at what point in time the police made contact with the complainant because it was a hit and run accident. I'm not sure if contact was made at the scene or later on, and there's not a whole lot of detail there. So Mr. Chapman is asking that the court consider keeping his personal recognizance bond in place, given that explanation, and potentially setting for a pretrial and bond violation combination in front of Judge Fresh-Hour so that if there is more detail that needs to be provided, Judge Fresh-Hour could consider that.
Your Honor, at this point, I have concerns given the nature of that bond violation with his wallet, his other property being in the car. He's not there. I would have concerns about contact with the victim, being there with her, especially given the nature of the charges. At this point, I would ask that he be remanded on the bond violation.
Your Honor, again, the only thing I will add is that Mr. Chapman explained to me that his wallet and other items were in the car when his mother provided the car to the complainant. So again, he's just asking that the court
Really?
consider. Yes, Your
That
Honor.
his wallet, ID, and all of his everything is still in his car.
Yes, Your Honor.
Clean sheet.
My understanding is that the car was supposed to be returned to his mother soon thereafter, and that Mr. Chapman said it was okay to leave his wallet in that case the complainant needed to use his debit or credit cards.
So how close was he when this vehicle crashed? Because they have him one driveway over.
Yes, so Your Honor, he states he did go to the scene of the accident after his mother told him that there was a hit and run crash. to check on his vehicle. However, it's unclear to me in the report, and based on what Mr. Chapman is telling me, at that point in time, the accident had already happened and the complainant was no longer there, and he was just going to check on his car. So again, I'm not sure because it's unclear in the
How
report
do I
whether,
know the complainant's not there if she had the car?
Um,
From this defendant?
so the complainant's not
Hmm?
at the scene of the accident.
Yeah.
Right, we don't know. And I'm saying that it's unclear to me when contact was made with the complainant, at what point in time.
I hear you, but none of that makes any sense to me because it almost seems like he's with the complainant, the vehicle crashes, she leaves, and he's still there. That's why the only thing that makes sense as to why his wallet, ID, all of that stuff is still there because he was in that vehicle when it crashed.
And that is not the explanation that he is providing.
I get that. Chris.
Yeah.
But none of the other part makes sense. Well, I'm not. Anything else?
No, Your Honor.
I think when I look at everything that the defendant was having contact with the victim in violation of the bond conditions in this case, and based upon what was said, at this time, I will move his pretrial date up to January 15th, 2026. That's still at 10:30.
Yeah.
January 15th, 10:30. But at this time, the court's going to believe that there's enough evidence and to indicate that there's been a bond violation. I'm revoking the defendant's bond. The defendant is remanded. So do you want to go to jail? I mean, because we can just cut to the chase. I can just send you down. Courthouse case, People versus Aaron Bucko.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Bucko, who stands to my right. Is there any for the record, sir?
Aaron Bucko.
Thank you, Your Honor. I am ready to address the warrant and the progress report if the court would like to hear about that first.
Yes, they would.
Thank you, Your Honor. As the court is aware, there was a progress report sent out. It was around Christmas, I believe it was the 23rd of December, that there had been some missed and late blows into the sober link. And at that time, there was a warrant issued. At that time, I did discuss it with Mr. Bucko.
Go ahead.
Oh, sorry, Your Honor. And at that time, I, of course, discussed the importance with Mr. Bucko of blowing on time. It to me at that time, of course, he stayed in constant contact with me throughout this case. He stated at that time that he has not consumed alcohol. He does take this matter very seriously, and largely due to those late or missed tests has to do with work. He does have full-time employment. He works in a warehouse. He usually works from 6 in the morning to 5:30 in the evening. He states to me, he works this schedule Monday through Friday. Once in a while, he'll even start a little early, working at 5 a.m. Again, he does this Monday through Friday, full time. He works at a replenishment, so often sometimes he misses the sober link blows or they come late. I did receive also a letter or an email.
Got a 3-hour window, so he's up for 3 hours.
Are you up for 3 hours at a time, Mr. Bucko?
Could be, it's different every time.
And
Go ahead.
I did discuss that with him and asking about if we could request the court to switch to a scram tether. He is asking at this time if the court would consider recalling the warrant and putting him on a scram tether. He did complete an alcohol screening and assessment through Ron Schwartz, which I just received yesterday afternoon and provided to Mr. Siller yesterday afternoon. That being said, there is a potential resolution in the works. So I guess I'll comment further on that a little bit, but I also received a letter in support via email from his mother, who one of the quotes in the letter was that she's not a mother who says that her child will do no wrong, but she did want to say that although she acknowledged this was a serious charge, but acknowledged that Mr. Bucko did take this seriously, and to her knowledge, she does not believe him to be drinking and does believe that a lot of this was due to the scheduling and the blows. I believe that Mr. Bucko will be able to show the court that he is abstaining from alcohol and is taking this matter seriously if he is able to be placed on a scram tether so that he can show that he has not been drinking. I do acknowledge as well that since that warrant was issued in end of December, that there was only one, based on the progress report I just received the other day, there was one further late blow. It appears that it was a 37-minute late blow. I'm not.
Yeah, but that is not, does not paint an accurate picture. Because what we had was, he had numerous late blows prior to the time prior to December 8th. We didn't just issue the warrant on him. We sent an order telling him he needs to comply with it, or the court was going to have to take further action.
That is, yes, Your Honor. Yes, Your Honor.
So,
And
go ahead.
oh, sorry, Your Honor. And I did remind Mr. Bucko of that. And frankly, there is no getting around the fact that he did blow late and that was a court order to blow within those time windows. And I got kind of serious with him and told him that he needs to comply and that there was that second chance given with the order to comply previously. Then there was the additional progress report that was submitted the end of December. Then the warrant. Since then, there has only been one late blow. Mr. Bucko does maintain he has abstained from alcohol. I'm not in receipt of any reports that he did test positive at any time for alcohol. Quite frankly, I'm asking if the court would give him yet another chance and put him on a scram tether so that we alleviate the whole window time. If he has any sip of alcohol at any time, day or night, of course it would register. That would be immediate bond violation and he'd know exactly where he would go immediately. He is asking for the court to give him another chance. He again maintains he's been staying abstinent, and it is our intention for him to hopefully start AA soon so that he can take advantage of a potential offer in the works. To that end, Your Honor, as to the pretrial, we were going to be requesting a brief adjournment. But as to the warrant, Your Honor, I'm respectfully requesting if the court would consider canceling the warrant.
You've said it like 8 times. I get what you're asking. Anything from the people?
Oh, and it's the court's discretion, Your Honor. The late testing is obviously excessive.
Yes. All of these couldn't have been related to work, could they?
I'm assuming that, yeah, they probably were.
So let me ask you this. There's a 3-hour window. Why aren't you blowing at the beginning of that 3-hour window?
I try to, whenever, like, in between those 3 hours, I try to do it like literally just whenever I can or whenever I get a chance. And sometimes if I am like at work, it just.
Because when I'm looking at this, I'm going to tell you what this tells me, man. That you're not taking this seriously.
I really am.
Because, well, but hold it. You have to understand how it looks to it. Certainly looks to me, because I sent you an order that you had to blow, and then I don't go a month and all of a sudden you just miss.
I understand.
So do you want to go to jail? I mean, because we can just cut to the chase. I can just send you down.
No, Your Honor.
Here with you.
My mom, my dad, and my girlfriend.
Okay, there's dad back there. Mom, I think I saw them moving to try to get closer. Did you get yourself enrolled in the GED program?
I did, yeah. Classes were starting in January, and then because I just turned 22, and they told I wasn't eligible because I was over the age of 21. So me and my mom are actively looking for a class. She can vouch for me on that, like a free one, because I was enrolled and turned 22. Because I turned 22, I wasn't eligible. I have the text from them.
So where did you enroll? You enrolled at?
Success Virtual Learning, I believe. It was online.
Oh, okay. And so then they said, once you hit the age of majority, you're not eligible.
Yeah, because I enrolled right before my birthday, because my birthday was December 23rd. And so once I turned 22, I wasn't like eligible to do the GED class anymore, because it was like a 21 age limit, I guess, that they had. But I am actively looking for.
Sometimes you don't take what you gotta do in life seriously, do you?
Sometimes I will admit, no. But this, I promise you, I was truly trying my best. I have not consumed any alcohol. Like when the warrant was issued, I had like asked if they could send me in for like a blood test or like whatever to like show that I haven't consumed.
Okay, but here's what you need to understand. It's not I'm worried about your consuming alcohol, because you have to understand you were a 0.223 and were able to operate a motor vehicle, which leads me to believe you were drinking quite a bit. And sometimes it's hard for people just to stop. But what I'm talking about is the missing of blows. Just I can't understand that. I get every once in a while something happens, and that's typically what that order was designed for. When I saw this one, we sent it, but I said, I hope he gets himself in the right place so that I don't have to send it. And expecting, quite frankly, after I sent out the order, that this is not what I would be dealing. You need to understand that when somebody misses a blow and I put you on a sober link and you miss a blow, I can consider that a positive test. You get that?
I understand.
When I'm talking about taking things seriously, you're telling me you're taking this seriously, but the whole discussion we had about you and graduating and all of that, and me listening to your parents, you got to take more of this seriously and understand you got to do what you got to do. You hear me?
I understand. Yes, I agree.
Mom, you want him back?
Absolutely, and I mean, as far as the missing, you know, he doesn't have a license, he can't drive himself to work. Some of his friends are only able to pick him up at 4 o'clock in the morning. I work from 5:30 till, so life is a little difficult with the rides, it's getting worked out. He is telling the truth, he did turn 22 on the 23rd.
No, I believe him.
We are looking for a program where
I got it.
his father can help out with getting him back and forth. What his girlfriend's willing to help out, I'm willing to help out.
Dad, you want him back? Yeah. Listen, probably should ask the girlfriend. You want him back? Because if you don't want him back, if you tell me no, then I'll put him away. You do? He had to breathe hard because he didn't know what she was going to say. Look, young man, I know you're trying, but you got all these people supporting you. They're all here. There is not a reason for you to fail on this stuff. It's the stuff you're messing up on. It's the easy stuff, right?
Yeah.
I'm gonna say it again. You are 0.223. I am just fortunate that I get to yell at you. Because at that level, you could have killed yourself.
He can actually tell you that he lost his brother-in-law for the same blood alcohol content. I don't feel like last year. a year ago.
Brother-in-law, you lost somebody? So you really know how lucky you are, right? All right, so young man, let's do this. Let's just try to start again. I'm not gonna lock you up. Okay? Let's just sort of reset this. Let's try to get you back on track. You're 22. Let's just get you back on track and let you try to do some great things in this world. How about that?
Thank you, Your Honor.
All right, so what I'm gonna do, I'm gonna adjourn your case to the 4th, February 4th, 2026. I want to see some progress in terms of get yourself an edgy, okay? And what I'm going to order, we'll do an order now. I'm going to order that you report over to the Department of Community Corrections. Best to do it before you leave here. You have your sober link with you?
Yeah.
Okay. So you have to turn that in. I'm going to put you on the scram tether. I'm going to give you a shot. And I'm going to tell you right now, most people with this blood alcohol level that don't comply with sober link, I don't even trust them on a scram.
Thank you, Your Honor.
And I usually just lock them up and that's it. I'm gonna give you a shot.
Thank you.
You gonna let me down?
No,
You better not.
I will not.
You know how I am. I get cranky.
You
Right?
have my word. Thank you very much.
You're welcome. All right, we'll see you on the 4th.
All right.
Thank you folks for coming down and supporting him.
Thank you, sir.
You're welcome. And young man, I mean it. Give your girlfriend a hug, because if she had said no, you would have been gone. All right? Take care, guys. Absolute disrespect showed up at another court, still under the influence of his drinking event that violates his bond in this case. Court calls case of people versus Joseph Hafner Cantor.
Alex Warren, Green Hafner Cantor.
Here, Your Honor.
Can you state your name?
Joseph Hafner Cantor. All right, what are we doing?
Your Honor, we're asking for a preliminary examination at this time.
Discovery is complete.
Believe so, Your Honor.
People have their witnesses available the 13th. Preliminary examination in person, January 13th, 2026, 9 a.m. before me.
Where?
Bond continued. Thank you.
I think the last time we were here was December the 4th.
Pardon?
Last time we heard was December the 4th. I have a violation dated December the 9th. Bond violation. 4th.
And we are in receipt of that, Your Honor. I did review it with my client.
You have a bond violation? I do. Behind that, I need these in the front.
So Your Honor, it does seem to indicate,
We were here last on what day?
I thought December the 4th.
Yes, I have December 4th. And I got,
So it does appear that these tests were in the interim period between the last time we were here and this.
Mr. Allen.
With positive alcohol blows on the silver link.
We've got a positive on December 8th. And then missed test really through the 9th, early into the morning. So the 8th was at 11:37 PM. 0.07. And then 04, probably the same alcohol, maybe a little bit more by 8 AM that morning. So some 8 hours later, he's still blowing numbers. Except that then a little bit later, it popped up and then went down. So it looked like he was continuing to drink. Then the worst thing happened. They spoke with him and he said he didn't have any alcohol.
And Your Honor, I believe Mr. Hafner Cantor is changing his position on that now.
Really?
He
Yes,
did
sir.
appear on the same day that this violation report was submitted. He appeared before Judge Frushauer to be arraigned on a misdemeanor OWI. The misdemeanor OWI date of the alleged offense predates this case. I think it was just authorized later due to lab results. But nevertheless, he appeared for arraignment knowing that this violation was there, and it was addressed at that time by Judge Frushauer, who had him taken into custody with a $5,000 10% bond. I think the condition of that bond,
On this case?
he was taken into custody at the time of his arraignment.
You're saying two different things to me. Her taking him into custody at the time of the arraignment is
Mhm.
one thing. If she's taking him into custody on this case, that's a different thing and not something that I see in this file.
And you're correct. What happened was, after the court considered this bond violation and received the report from his tether agent, bond was set in the amount of $5,000, 10%, with the condition that he be fitted with a scram tether before that bond shifts to a personal bond. So he was fitted with a scram tether. He remains on that scram tether since December 9th, and I don't believe he's had any violations. Mr. Hafner Cantor is employed and has stable housing with his employer in Saline. Your Honor, I would ask the court to consider continuing his bond, because I think him being on a scram tether is kind of the constant reminder he needs not to drink. I will note the present offense. I don't believe there are any alcohol related allegations, but of course he does have a misdemeanor OWI, and he admits he has a drinking problem.
Yeah, but this response from the people.
The people are glad that he has now a scram order on the OWI case that's pending before Judge Frushauer. However, it's still a violation in this case to have been drinking. I'm not sure. I know the court generally will issue warrants pretty quickly when these things sort of come through. I'm not quite sure what happened here, but no matter what, it does.
Was there a warrant issued on this one?
It does appear to the people that alcohol is a significant problem for the defendant. It appears that SoberLink is not working. So I would ask that the court at the minimum order the scram in this case as well.
Did he take the ETG?
Doesn't look like it from this report.
He did not give me one.
So there was a warrant issued on this one, okay.
Okay.
Is it still out?
For Mr. Hafner.
Yeah.
Okay.
No, I do not see that one.
Oh, you do not see that
I
one.
do not see. No.
So he was, the report says, I advised him to report to community corrections for an ETG urine test by end of the day. This is on 12/9. He said he had court and only had transportation there, doesn't have any money to take the urine test. I advised him a violation be sent, and I was affording him the opportunity to take ETG test to provide results with my report if in fact he was not drinking. And I just confirmed with Mr. Cook. Mr. Cook informs me that the defendant had a positive BAC coming into court. I'm not sure if that's related to this violation report or if it was actually going to court, but it does all appear to be on the same date, that December the 9th sort of timeframe.
So when did he appear before Judge Freshour?
It looks like December the 9th,
That's correct.
What time?
9-ish in the morning.
So she may or may not have been aware then,
She was aware, she remanded him and.
but was she aware that he was intoxicated?
Mr. Cook's note indicates, and his communication to me indicates that, he had a positive BAC coming into court. I'm assuming that means he was blowing numbers at court. And I know that community corrections was there.
Okay, I'm pretty much done. I mean, you drank coming into court, you drink in violation of my bond. I saw you 4 days beforehand. And no,
May I speak?
we don't do that. Say whatever you want.
Your Honor, I think what Mr. Hafner wants the court to consider is that since this string of events leading up to the court date on December 9th, I think he has pivoted and changed his position from denying
So let me
his
get this
problem.
right. You're telling me that all of a sudden everything has changed. On December 8th, he's drinking. He's drinking well into the morning on December 8th. He has to appear in court, can't stop drinking, and then ends up at court that day. He talks to community corrections, I think, on that same day and just is absolutely lying to them. And somehow between now and that date, he has made a certain epiphany has occurred and he's made some miraculous transformation. Is that what you're telling me?
Your Honor, I understand the court's concern. Mr. Hafner-Cantor, when were you released from the Washtenaw County jail? Was it the following day or this?
I was there for a week. I think I was released on the 19th or the 18th.
So, Your Honor, he's strung together 10 days on a scram tether with no issues whatsoever. And I think that's what he wants the court to consider in reassessing bond here. I would ask the court to continue his bond based on the fact that he's come into compliance since being placed on the scram tether.
He's in violation on my case, goes to another court drunk.
And Your Honor, I would like to correct my record I made to make sure that it's accurate. Mr. Cook has let me know that he doesn't know if the defendant was individually touched at the court, but because he had the .04 30 minutes before the judge saw him, Mr. Cook's note was that he was drinking. So I apologize if that was confusing at all. I just want to make sure.
So he wasn't breathalyzed at court.
Now that Mr. Cook is aware.
Where
But
it's because it was 30 minutes before, there was an assumption that, which is a good assumption.
it's pretty fair, yeah.
Anything else?
Your Honor, I know Mr. Hafner-Cantor's been in constant contact with his community corrections agent, and I know that his 3-year-old daughter, who he takes care of, is his biggest concern. I think he was dealing with some stress regarding a custody situation with respect to his daughter, and
He's violated my bond. And then absolute disrespect showed up at another court, still under the influence of his drinking event that violates his bond in this case. And he's appearing at that time on an OWI. And he's not in any treatment. Anything else?
Nothing from the view.
nothing further, Your Honor.
Bond revoked, defendant's remanded.
Your Honor,
Yeah.
and
The 13th is.
And with respect to that date, he does appear in district court on that same date. I'm not sure if the court wants to move it or if the jail would be able to accommodate that
District court where?
for the OWI case.
Well, he wouldn't exam until much later.
Which judge is the exam?
Eh.
Thank you.
Thank you, Your Honor.
In today's packed court session, Judge Simpson dismissed one case due to major discovery failures by the prosecution. In the second case, he revoked bond for repeated violations and drinking while on conditions. These hearings show the challenges of supervising defendants and the importance of following court orders. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. 64039